Hi! In this second clip, I would like to discuss the question of how states come about, or to put it more succinctly, of statehood and state recognition. I'll elaborate in the third video on what the various advantages are of being a state, but I think you already know, not just from the first clip, but also from previous sessions, that there is really a lot at stake when it comes to statehood. Being a state means that you're sovereign, means that you're a primary subject of international law, and as such, of course, is something that many peoples in particular strive for. Given the immense importance of this question, you may be dismayed to hear that it is not easy, not straightforward to answer it, and we know what complicates matters here, as already mentioned in the previous video. This is because there is no overarching authority in international law, and in fact, it is up to the community of states to decide in a sort of horizontal way what counts and what does not count as another state. In order to explain this process, describe this process, there are two competing theories which I will both address separately. On the one hand, the declarative theory, and on the other hand, the constitutive theory. What complicates matters further is that these theories are mutually exclusive and in fact competing. And students in particular find it very frustrating that they have to account for their coexistence and that there is no straightforward answer to the question of statehood in some cases. Now, what I will do here is to explain the advantages and disadvantages of each theory, one important aspect of which, and I think that's also something you can already remember, one of the important aspects of which is the explanatory power that each theory has. On the one hand, we have the declarative theory, and one might even argue that it is the more intuitive and more straightforward theory. And it basically suggests that the question of statehood depends on a number of objective factors, objective criteria, and the question of whether something actually qualifies as a state is answered by looking at these criteria and checking whether each and every of these aspects is fulfilled. So what are these criteria then? Well, they are put down in the 1933 Montevideo Convention, which by itself is applicable only to a handful of states in the Americas, but it is generally considered to reflect the criteria of the declarative theory. The first one is that there should be a territory. The second one is that there should be some sort of permanent population. The third one is that there should be an effective government. And the fourth one is that there should be a capacity to enter into relations with other states. The textbook discusses each aspect, so I will not do this here in an elaborate way. Safe to say, though, if we look at the international community, if we look at the variety of states, we see that these criteria can and are met in different ways. There are smaller and larger states, both in terms of territory and population. There are a variety of forms of government. However, what's important is that these objective criteria are somehow met, and as importantly, that they are met on a sort of permanent and stable basis. So, according to the declarative theory, if an entity meets these objective criteria, then it can and arguably should be recognized as a state. If states were to follow this conception, then the question of statehood would always be straightforward and would always find a clear objective answer. But this, as you already have guessed, is not the case. Not only have only 16 states ratified the Montevideo Convention, but if we look at state practice around the world, we see that other and notably also political considerations really play a major role when it comes to state recognition. This already brings us to the second theory, the constitutive theory, which basically holds that state recognition, international legal personality, is conferred by other states through the act of recognition and regardless of any criteria that would be applicable. So states might want to base themselves on the Montevideo criteria that we saw, and in many cases they will consider these to be sort of prerequisites. However, they don't have to extend recognition, which means that even if an entity meets the objective criteria, and this has happened in some cases, it will not be recognized by a state as an equal peer state. Now, this might seem arbitrary, and in many ways it is, and it does not live up to the expectation that we might have for a legal system. However, the advantage of the constitutive theory is that it corresponds more to reality. It tells us in particular the degree to which an entity, a state, actually is able to participate in international legal relations, the extent to which it is actually able to exercise its international legal personality. Think, for example, of Palestine, which has been recognized by 139 out of the 193 United Nations state parties, which means that it can enter into legal relations with these 139 states, but not with all states in the world. It also means that it has not joined the United Nations as a full member, most notably because in the Security Council its membership is blocked, for example, by the United States. So Palestine is able to conduct some legal relations, is able to display some international legal personality, but there are limits to it, which quite neatly in a way reflects the 139 out of 193 recognitions that it has achieved so far. By comparison, Taiwan only maintains formal diplomatic relations with 12 other states, which is a number that, due to the pressure by the People's Republic of China, has been continuously decreasing ever since I taught this course for the first time. And what is notable here is that this number diminishes and is quite small as compared, for example, to the 139 by Palestine, despite the fact that Taiwan arguably meets the 4 criteria of the Montevideo Convention. So, if each recognition matters, and if the totality of recognitions sort of reflects your degree of international legal personality and your capacity to participate as a primary subject in international law, then the downside of this constitutive theory is that there are no clear-cut answers to, in particular, the hard cases. There is no "this is a state" or "not a state" objective answer, which we arguably would have if all states were to follow the declarative theory. That said, the problem might not be as big as it appears at first sight, because most states in the world, states as large as the People's Republic of China and as small as San Marino, count as states under both the declarative and the constitutive theory. Their status, again for most states, is not in question when it comes to international law and the international legal subject. This concludes the second clip. I will now move on to discuss the role of peoples, the right to self-determination, and the relevance of statehood.